Hi, my name is Aaron Lacey. I'm the chair of the higher education practice at Thompson Coburn LLP, and you are listening to Title IX Appeals, the last in our Title IX training series. We are so pleased you're with us today, and if you've been listening to all the prior sessions, this is 6 of 6. Congratulations, because you've gotten through a lot of training. We've got another good discussion for you today. I can also promise you that it's going to be the shortest of the 6. So if you've made it this far, you're almost to the end. For those who don't know, Thompson Coburn is a law firm headquartered in the Midwest. We're pretty big. We've got offices around the country, and we have a higher education practice. And the folks you see on your screen right now, these are lawyers who either work with higher education some of the time, or in many cases, all of the time. I myself spend 100% of my day working with colleges and universities on a range of matters. And the practice broadly, many of these folks work on allegations or issues involving discrimination on the basis of sex or race or disability or some other protected class. The purpose of this training series is to assist institutions in complying with the new Title IX rule that becomes effective August 14th, 2020. Pursuant to that rule, institutions of higher education are supposed to provide training for all the individuals who will be participating in, and I mean the internal at the institution individuals who will be participating in and helping to administer the new formal complaint process. So we're talking about investigators and adjudicators and potentially appeal officers and advisors and others. Not only are you required to train those folks, but you're also required to post that training to your external website that you use, all of your training materials. So we understand, given the pandemic in particular right now, that it is hard to identify, or may be hard to identify, resources and deploy those and make them available to these various individuals. And that's why we created this series. To be clear, we are very happy for you to post it to your external website or to use it at your discretion now and in the future. And if you would like custom training, this is foundational training. There's a lot to it. So we do have 6 sessions and we go through a lot. But if you'd like custom training on your policies, or if you'd like to do some sort of hearing simulation or investigation simulation, things along those lines, give us a call, because we help institutions with those types of trainings as well. I mentioned earlier, this is our training series layout. It consists of 6 modules in its entirety, and you are watching the final module on appeals. The session today will have just a few parts. This is our syllabus. You see this in every one of our sessions, and we've got, I guess it's 5 different topics to hit on the syllabus. I'll go through the first one, the formal complaint framework, fairly quickly. I do that at the beginning of every session, just to get people, as I like to say, sort of get your mind right so you remember where we are and things. And then our 2 presenters, we have Judge Shaw back and Scott Goldschmidt as well, and they'll be working through these various topics. I mentioned Judge Shaw. He was in our prior session on hearings as a trial judge in the state of Missouri. He oversaw literally hundreds of hearings, and he also sat for several years on the Missouri Court of Appeals. So this gentleman is a professional adjudicator in every sense. And if you went through the hearing, if you haven't heard the hearing session, I hope you'll go back and listen to it, because it was really good. And he brought that sort of experience and perspective of a career adjudicator. If you are someone tasked with managing Title IX hearings or appeals, these will be sessions you want to listen into. So we have the Honorable Judge Shaw, and we have the estimable Scott Goldschmidt, former Deputy General Counsel at Catholic University, who's been present in all of our sessions. Scott, thank you so much for being back today, to you and Judge Shaw, and for walking us through the appeals process. Right before you do that, though, before I hand it over to Scott, just a reminder, the new rule. So we talk about Title IX, the statute, which broadly prohibits discrimination on the basis of sex at institutions of higher education. And anytime an institution gets a complaint or an allegation of discrimination on the basis of sex, they've got to have a process for working through that. But keep in mind, that could be any type of allegation, not just sexual harassment. So you could be dealing with claims that there was discrimination in the context of housing or admissions or counseling, anything along those lines, athletics. An institution would have a process in place and need to respond. The new rule is really focused on what institutions should do if they get a complaint of what we're calling Title IX sexual harassment. In the very first of our session, Scott went through this definition under the new law of sexual harassment. And if you get an allegation of sexual harassment that satisfies that definition, then there are obligations under the new rule. Even more specifically, if you get a formal complaint of Title IX sexual harassment, and that's the orange box here, that's the core of our concern. If you get a formal complaint that there's a lot, then there is a lot you have to do. And that's really what this new training series is focused on. And it's what the new rule is focused on. We've got the definition of formal complaint here. We're talking about a written complaint that you receive either from the complainant or Title IX coordinator that alleges sexual harassment and is seeking an investigation. So it's got to be in writing. It needs to be signed. It could be electronic or hard copy, but either way, it's got to be in writing. If you get that formal complaint, though, then you have to initiate your formal complaint process. And that's where all this machinery sort of comes into place. And that's, again, what the new rule is primarily focused on. And you can see our series, these are all the different elements of the formal complaint process that are laid out in the new rule. And our series, training series, is largely focused on walking through these elements. And as I noted before, you're almost at the very end. We did record keeping in the first session. We tied it in. So in a sense, appeals is actually the end of the line here, at least for our training. So with all of that having been said, I'm delighted to turn it over to Mr. Scott Goldschmidt.
Thanks, Aaron. I think let's just dive into a few key concepts with appeals. So first, we'll just kind of go over the general overviews, requirements of the regulations, and then we'll turn to Judge Shaw for some of his opinion and experience based on actually doing a lot of these. So first, key concepts for the appeals. So schools must offer both parties an appeal for one, the determination regarding responsibility. So if you get to a formal hearing and adjudication and there is a determination on responsibility, that is one time an appeal must be offered. The second time an appeal must be offered is regarding the school's dismissal of a formal complaint or any allegations herein. Now, we've discussed this in more detail in the formal complaint module, but remember, there are points before a formal adjudication where the school either may or must dismiss a formal complaint. And this is another point where an individual the school has to afford an option to appeal. Schools have to implement their appeal procedures equally for both parties. We're going to go over the basics of what the rule requires, the floor, but to the extent that there are any additional requirements or inputs in procedures, they have to be applied equally. Schools must notify the other party in writing when an appeal is filed, and schools must ensure that the appeal officers, not the hearing coordinator, investigator, I'm sorry, not the adjudicator, the investigator, or Title IX coordinator. And we'll go into a little more detail about maybe people that might be good serving as appeal officers. In addition, schools must ensure the appeal officers received required training. We'll explain what that required training is according to the regulation. Institutions must give both parties reasonable, equal opportunities to submit a written statement in support of or challenging the outcome. And that we'll discuss. The schools have to issue a written decision describing the result. So after the appeal officer reads the appeals and both parties have had a chance to state their case, there needs to be a written decision describing the results and the decision of the appeal officer, and that decision needs to be provided simultaneously to both parties. So let's turn to what can you appeal on? So the statute, the regulations have three applicable bases for appeal. So the first that the schools must include is a procedural irregularity that affected the outcome. The second is new evidence that was not reasonably available at the time the determination or dismissal was made and could affect the outcome. And third, the Title IX coordinator or investigator or adjudicator had a conflict of interest or bias that affected the outcome of the matter. So what's important to note here is these are fairly specific bases for appeal. The department's not saying that if one party is dissatisfied with the outcome or they just generally think that something could have gone better their way, they could appeal that. The actual appeal needs to be based on one of these three narrow specific outcomes. That being said, the department also makes clear that a school can offer other appeal grounds equally to both parties. So by their process, they can say, I have appeal rights 4, 5, and 6, and I'm going to make them available equally to both parties. But even if the school decides to add additional bases of appeal, it doesn't mean that that there's a general right to appeal. You have to be really kind of focused and based on these specific grounds, and the appeal that the complainant or respondent submits needs to explain why one of these bases is effective. So Judge Shaw, let me kick it to you for first question here. So we just went over the 3 mandatory bases of appeal in the regulations. I didn't see anything about severity or proportionality of a sanction. Is that an appropriate basis for appeal under these rules?
Well, it could be if the recipient decides to make it a basis for an appeal. I mean, the 3 you pointed out are the only ones that are mandatory. But I would suggest that severity or proportionality of sanctions may be an appropriate basis, but of course the recipient has to state that it is and offer it to both parties.
Makes sense. And then what about a party just requesting an appeal because of general dissatisfaction with the result?
Well, somebody's going to be dissatisfied no matter what the result is. So no, you can't appeal just because you're dissatisfied. It must meet one of the 3 criteria you just talked about, Scott, or any additional ones the recipient chooses to implement.
And if a hearing officer received an appeal based on just general dissatisfaction, how would they adjust that? I'm sure you've, as in your previous career, have had plenty of those. How would you address something where an individual made an appeal based on a ground that was not specified as permitted by your regulations?
That's what the court would say to us, is that the appeal is denied because it was not based upon a ground specified and permitted.
So what about this? Is you're not satisfied with the appeal officer's decision? Who do you appeal that to?
Well, you have the right to file a lawsuit, but your appeal process is done. And, I think, I guess circling back just a little bit, I think people often feel, lay people often feel that an appeal is a do-over. It's not a do-over. I mean, there are certain limited bases upon which you can appeal, and appeals are not unlimited. The process, you've often heard, justice delayed is justice denied. I mean, the process must come to an end, must come to a conclusion for the sake of all parties concerned. And so there's one appeal, and if a party is dissatisfied with that appeal, then they can file a lawsuit.
All right, let's move on to talk about drafting appeal decisions. So we talked in the previous couple slides about what applicable bases and what happens when someone files a appeal that maybe doesn't meet one of those bases. But now let's talk about when someone files a proper appeal. It meets one of the bases in your procedure, and you have it in front of you, and you kind of have to go about evaluating the facts and the decisions. Judge Shaw, what are some things that appeal officers can consider as they're reviewing appeals and ultimately drafting those decisions?
Well, as you've indicated, Scott, it has to be based, the appeal has to be based upon one of the applicable grounds. And once that determination is made, that is, the appeal is made on an appropriate procedural ground, then what are the allegations there? And of course, the appeal officer must have an open mind about it and not give any particular weight to one side or the other, and objectively make a determination as to whether or not those grounds for appeal have been established. Now, the one thing, of course, that I think the appeal officer is going to have to give deference on, and that is on matters of credibility, because the appeal officer will not be considering the witnesses again. The appeal officer, if the hearing officer makes a determination that one witness was more credible and believable than another witness, or that the witnesses were equally credible on certain points, then there's no way that the appeals officer can find differently because the appeal officer will not have a do-over. They won't hear the witness. They will just look at these bases that have been offered to them. But otherwise, I don't think that there should be any particular deference one way or another about the validity of the finding by the hearing officer, and that the appeal should be considered with an open mind and objectively.
So kind of going off of that, what facts, what documents would you expect a hearing officer to have in front of them, and what would you, if you were a hearing officer, what would you want to have in order to make your review, your decision?
A hearing officer should have each and everything. I mean, the appeals officer should have everything that the hearing officer had. Transcript, documents, statements, anything that was considered by the hearing officer, as well as any evidence or documents that may have been rejected in case there was some procedural irregularity with regard to a relevance determination. So they would have to consider the whole record to appropriately consider the appeal.
Judge, let me move back a little bit. We talked about the appeal bases, and the three bases by the department were procedural irregularities, new evidence not available, and conflict of interest or bias. And each caveat is at the end of each point. It's that they have to have affected the outcome of the proceeding.
Yeah.
What does that mean to you in terms of if you get an appeal based on one of these factors that it affected the outcome?
Well, let's say, now of course it has to be determined on a case-by-case basis and according to the facts and evidence that was presented in each case. But if this procedural irregularity or new evidence had been cured at the time of the hearing, if this evidence, for instance, that had been excluded would have been allowed in, if this new evidence that was not reasonably available was available to the hearing officer, was that evidence of such weight and of significance, materiality, and relevance that it would have changed the outcome or might have changed the outcome? One of the things that I think the hearing officer and of course the appeal officer considered is whether there was an appearance of impropriety and whether reasonable minds would conclude that this evidence, whether excluded evidence or newly discovered evidence, might have affected the outcome. The harder call can sometimes be whether or not there was a conflict of interest or bias. And I think that is why the hearing officer has to be very careful about, is there even an appearance that a social relationship or a professional relationship might have affected either the hearing officer or an investigator in the case. And of course, those things should have been cured at the hearing, because you may find yourself, if there is even the appearance that there is a possibility that a conflict of interest or bias could have affected the outcome, you may have a problem with the perception that this was not a fair hearing. And the appeals officer may be in a position to say, well, I don't know. It's hard to read minds. I don't know if this might have affected the outcome. Now, if the relationship is so attenuated, so distant, and such that one can very reasonably say, okay, this could not possibly have made any difference. In a closer call, I think the appeal officer may be forced to offer a new hearing under those circumstances and send it back. So, but otherwise, I think it just has to be on a case-by-case basis, and the appeals officer has to look at that evidence and make an objective determination as to whether or not they think it may have affected the outcome one way or the other.
Just to button up this point, if the appeal officer thinks that it would not have affected the outcome, if they reasonably kind of say maybe there was a procedural irregularity, but it wouldn't affect the outcome, how would an officer decide in that case?
if it would not have affected the outcome, then it cannot be the basis for overturning the findings at the hearing.
Okay, perfect. Thank you. Yeah, I just wanted to button that up for
Yeah.
my understanding.
Sure.
So let's talk about. You mentioned before there's no appeal to the appeal, but you could file a complaint with the Office of Civil Rights, or you could file a lawsuit. So I think all appeal officers have in the back of their head this is a possibility. What about? So in drafting an appeal, what can an appeal officer do to make it as defensible as possible in case it is ever reviewed by an administrative agency or a court at a time?
Yes, well, it's much like the Court of Appeals does. I mean, you have to address each of the points on appeal, and it is the claims raised on appeal, and say why they either did or did not necessitate a new hearing or require that the findings at the hearing be affirmed. And the more succinct, the better.
Perfect. Thank you, Judge Shaw. With that, I think that takes us to some potential requirements or characteristics of good appeal officers. So I think this is not an easy job, along with being an adjudicator. Appeal officer is not an easy job. So in your experience, what would be some good characteristics, some things to look for when an institution's deciding who they should make their appeal officer?
Well, I think, as we have discussed before, that the appeal officer should be someone who has, I think, no conflict, no bias, and be of such a stature within the institution that they lend a certain gravitas to the decision that they've made in the case. I think it would be someone who has a reputation for being objective and thorough, a detail-oriented person, understanding the process, and not afraid or concerned about any repercussions based upon whatever their decision may be.
Do you think institutions need to look for a lawyer or someone with legal training to do this kind of analysis?
I don't think they should exclude lawyers, but I don't think that it's necessary to have lawyers.
Okay. Very helpful. And so institutions, I think as Judge Shaw explained, potentially, I don't think you might want your president or CEO to be hearing these appeals, but maybe someone at the step below, a vice presidential level at the institution, or someone kind of in charge of the process could be a good potential officer to hear.
Scott, I'll actually go a step further and say you definitely do not want your president or CEO or general counsel hearing these appeals. You definitely want someone who is not the foremost representative or legal counsel to the institution.
Fair enough. Yeah, that makes sense. But then I think that brings us to the requirements for an appeal officer. So I think Judge Shaw gave us a great outline of what would be expected in an ideal appeal officer, but in terms of the regulations, they explain that appeal officers must receive training on the following. So the definition of sexual harassment under the statute, the scope of the institution's program or activity, and that, as you may remember from a previous module, that's a defined term about kind of where the institution has authority to hear Title IX hearings, how to conduct an investigation and grievance process, so including hearings, appeals, informal resolutions as applicable, how to serve impartially, including avoiding prejudgment on the facts at issue, conflict of interest and bias, and specific to your institution, along with the scope, and any technology used at the live hearing, and on questions of relevance and evidence, including questions and evidence about a complainant's sexual predisposition or prior sexual behavior, and explaining that those are not relevant. So Judge Shaw, let me throw this to you. You mentioned that it's important that appeal officers do not have conflicts of interest or bias before. But what happens if an appeal officer does in a certain case, or you suspect they do?
Then that appeal officer should be disqualified. And as I said before, for the viability of the process, it's essential that there not even be the appearance of impropriety in these proceedings. And so, much as we do in courts here, we avoid even the appearance of impropriety. Sometimes it's that a judge might say, or in this instance, appeal officer or hearing officer might say, well, I don't have any bias or conflict of interest. I can set that aside, kind of thing. But it is an objective determination. Is there a reason to believe that this relationship or this situation is one in which parties may believe that there is a conflict or a bias there? And so, to avoid even the appearance of an impropriety, it's best to avoid someone who has a potential conflict or bias.
Perfect. And I think for that reason, institutions should make sure that they just don't have one person that could be the only appeal officer, or a system to designate that appeal officer for in case they are unavailable, in case they have a conflict, or in case the complaint is about the appeal officer. You don't want to have a policy mandating that person has to hear the appeal of a case that might involve them.
Yes, for sure.
And I think with that, Aaron, I'll flip it back to you for a discussion of resources.
Thank you, Scott. And thank you to both you and Judge Shaw for another tremendous conversation today. So we'll walk through our resources one last time. First of all, I just want to remind everybody that the Office of Civil Rights has their blog, which is where they have said they're going to post guidance and interpretation on a go-forward basis relating to this new rule. So if you're counsel or coordinator, you'll definitely want to have the Office of Civil Rights blog in your browser. We have a comparison document that we created, which shows the changes the new rule made to the existing regulatory framework. It should be located where you can find the slides for these presentations, hopefully near the videos. If you can't find it, just give me an email or otherwise a holler and I'll get it to you. But if you're like me, it's very helpful to see the exact changes that were made to the regulation. We have a higher education webinar series. We'd be delighted for you to join us. The webinars are all free, and you can also get them on demand after the fact, again, free if you weren't able to catch them. They're usually offered from August to May. We sort of track the academic year. We cover a range of topics, and again, would be delighted for you to check them out. We also have a higher education blog where we write about a wide range of policy and regulatory issues that impact higher education. Regulation is what we call that. We've been writing a lot about the CARES Act recently, but we cover topics of discrimination like Title IX also on a pretty regular basis. Let's see. And sometimes we have free tools that we make available, and we encourage you, if you want to sign up for those, you can get our alerts. Here's an example. We did a bar defense reporting guide. So folks under another rule that became effective July 1 of 2020, institutions have to report certain information to the Department of Ed, and we put together a little guide to help them out with that kind of thing. Once again, all free and available. Just let us know if you'd like to sign up for these kinds of things, or otherwise have these resources sent to your inbox. Finally, if you'll wait a few moments after this, you'll see extended bios for Judge Shaw and Scott and myself, and at the end, our legal disclaimer that just reminds you that we are not your attorneys. Hey, this is the last session of the 6. If you made it through all 6, congratulations. That's a lot of training, a lot of complex ideas to wrap the brain around. We hope you found it informative, and we actually certainly enjoyed bringing it to you. And then one last thing, at the end of every session, I say this, and I couldn't be any more sincere. I've mentioned several times, we're doing this amidst the pandemic. We know all of you out there at institutions of higher education, if it's still the middle of 2020 when you're watching this, are also operating amidst the pandemic. And frankly, even if it's after the pandemic and things have all hopefully gotten back to at least a new normal. Regardless, we always want to wish you and hope for you that you will be safe and be well. Thanks, everybody.